Good afternoon, ladies and gentlemen, colleagues, attendees. We are beginning the panel session for the defense of the Thesis by Natalia Diatlova. The Thesis is submitted in conformity with the requirements for the academic degree of the candidate of science in law. Specialization is 120003, civil law, commercial law, family law, international private law. The topic is public-private partnership agreement, civil law aspects. By Rector's Order number 3603/1, as of the 5th of April 2018, I, Professor Dmitry Petrov, Doctor of Science in Law, Associate Professor of the Department of Commercial Law of St. Petersburg State University, was appointed Chairman of the Dissertation Board. Allow me to introduce the members of the Dissertation Board. Oleg Gorodov, Doctor of Science in Law, Professor of the Department of Commercial Law, SPBU. Alex Skvartsov, Doctor of Science in Law, Professor of the Department of Commercial Law, SPBU. Inna Yershova, Doctor of Science in Law, Kutafin Moscow State Law University. Head of Department, Professor of the Department. Igor Martinenko, Doctor of Science in Law, Yanko Kopala State University of Grodno. Professor. All the board members are present here today. So the composition of the board corresponds all the necessary requirements. Under the federal law as of the 23rd of May 2016, on amending Article 4 of the Federal Law on Science and State Scientific and Technical Policy, SPBU is entitled to confer academic degrees. The corresponding order number 6821/1 on the procedure of granting academic degrees at St. Petersburg State University was issued on the 1st of September 2016. According to item 17 of section 3 of the regulation on the Dissertation Board in St. Petersburg State University, the panel discussion is valid providing 2/3 of the appointed board members are present. The total number is not to be fewer than 4 people. The Dissertation Board today consists of 5 people, 5 of which are present. Therefore, we have a quorum. The panel discussion cannot exceed 2 hours. Now let me announce the agenda. Number 1, the chairman's presentation about the documents submitted by the candidate for the degree and their conformity with the requirements. Chairman's reply to questions, if any, no more than 5 minutes. Number 2, the candidate's presentation providing an overview and findings of the research, no more than 15 minutes. Number 3, questions to the candidate regarding the presentation, no more than 2 minutes for each question, and the candidate's reply to the questions. We haven't received any external report on the thesis, so we are not going to read them out. Then we have reports on the thesis by the members of the Dissertation Board, no more than 10 minutes per person. Chairman's presentation of his report, then the candidate's comments about the reports on the thesis, no more than 15 minutes. Questions from the audience. The floor will be given to the Node Board attendees. They can give a brief account of their ideas and or ask questions to the candidate about their research. No more than 5 minutes per person. It is necessary to fill in the registration form and give their full name before the talk, because the panel session is being broadcast and being recorded. This is done to facilitate an open discussion. The candidate comments about the talks given by non-members of the board, no more than 5 minutes. Presentation of the candidate's thesis supervisor, Professor Vladimir Popandopova, no more than 3 minutes. a 5-minute break before the open balloting on conferring or non-conferring the academic degree. Discussion of the results of the defense is not broadcast. Then we have open balloting, vote counting and recording the results in the minutes of the session. Finally, deciding upon conferring or not conferring the academic degree. After that, the candidate will be given the floor to give a closing speech, no more than 2 minutes. So this is our today's agenda and the time outline. Before we proceed with the agenda, I kindly ask you to switch off your mobile phones so that it doesn't disturb the session and doesn't lead to any technical difficulties. The panel session of the dissertation board is being recorded and broadcast on the internet and interpreted into English. This is the general outline of the session. So let's start with implementing the agenda. The first item, as I announced, is the chairman's presentation about the documents submitted by the candidate. The thesis by Natalia Diatlova is submitted in conformity with the requirements for the academic degree of the candidate of science in law. The specialization is civil law, commercial law, family law, international private law. The topic is public-private partnership agreement, civil law aspects. The thesis was approved for defense by the order of the SPBU Academic Secretary as of the 5th of April 2018, number 3600/1. The dissertation board was set by the order of the SPBU Academic Secretary as of the 5th of April 2018. Order number 36603/1. I have already introduced the members of the dissertation board. The candidate has submitted the following documents to the SPBU Academic Secretary. Number 1. An application to Professor Nikolai Kropachev, Rector of SPBU, on the approval of the thesis for defense. It was submitted on the 19th of January 2018. A report of the academic supervisor, Professor Vladimir Popandopova, Doctor of Science in Law, Head of the Department of Commercial Law, SPBU, signed 21st of January 2017. List of published works containing 4 items. 3 works are published in peer-reviewed journals recommended by the Ministry of Education and Science. The list of scholarly works can be found in the dissertation, which is posted on the university's official website. The next document is a letter of verification number 04A355 issued by St. Petersburg State University. This certifies that Natalia Diatlova from the 1st of September 2014 to the 31st of August 2017 was enrolled in the postgraduate course at St. Petersburg State University. Field of study 400601 Law. Specialization 120003 Civil Law, Commercial Law, Family Law, International Private Law. This also certifies that she passed the qualifying exams. She has also submitted a letter of verification issued on the 27th of June 2014, number 0412298, that Diatlova Natalia passed the qualifying exam in specialization 120003 with a mark good as well as philosophy and English with marks excellent. The next document is a university diploma with honors issued to Natalia Diatlova, maiden name Apagina, that in 1996 she completed the program Law with the qualification of lawyer. And finally, a thesis in Russian and English, a printed version with the manuscript copyrights and the digital copy. The thesis formatting and reference list comply with the state standard. Let me underscore that all the above-mentioned documents complied with item 12 of section 3 of the order on granting academic degrees in St. Petersburg State University. This was the list of documents that allow the candidate to participate in the defense session today. Now the floor is given to the candidate.
Distinguished members of the Dissertation Board, the thesis is devoted to legal and civil aspects of public-private partnership agreements. In this thesis, we try to analyze and give a complex assessment of the legal nature of public-private partnership agreements. We deal with such issues as the object and the subject, the content of the agreement, also the conclusion, termination, and modification of the agreement. We also justify the amendment to the law on private-public partnership agreements in order to attract investment and attract financial attractiveness to the public-private partnership agreements and projects. And finally, we want to improve the legal regulation in this area. Rapid development of the legislation on public-private partnership agreements in conjunction with a low number of finalized agreements in this area reaffirms the urgent need to develop conditions for their successful application. Although there are some scientific works in this area, this issue has not been sufficiently studied in Russia, and therefore the quality of the research works that we have sometimes is not quite high. In the thesis, we take into account Federal Law number 224 on public-private partnership, municipal-private partnership in the Russian Federation, and amending certain legislative acts. And we also take into account the legislation of England and France. In my job, I deal with the implementation of public-private partnership agreements, namely the Western High-Speed Diameter Highway, and I made use of my practical experience in the thesis. The novelty of my thesis is that we are studying the issue taking into account the law on public-private partnership agreements and the legislation of England and France. Here are the statements to be defended. In the thesis, it is found that by its legal nature, the public-private partnership agreement is an independent rather than a mixed type of contract. It is found that the nature of the public-private partnership agreements is determined by civil law provisions, but they establish relationships containing both private and public law elements. Number 3, it is recommended that the law on public-private partnership agreements should specifically indicate that an obligatory element of the public-private partnership agreement should include minor reconstruction of the property as a part of the concept of the reconstruction of the object of an agreement by the private partner. To reduce the risk of contesting the transfer of the object of the public-private partnership agreement into the ownership of the private partner in case of only minor reconstruction, the law should include the provision that the law on privatization does not apply to the public-private partnership agreements, which are regulated by the law on private-public partnership agreements. Number 4, it is proved that the list of public-private partnership objects should be extended. To this end, we recommend either a non-exhausted list of objects that cannot be transferred under the public-private partnership agreements, or a comprehensive list of areas of applications within which the public-private partnership agreements may be concluded and implemented. Number 5, it is recommended that the law on public-private partnership should envisage a comprehensive list of violations which restrict competition during the tender or provide for their specifications in the subordinate legislation. This act as a criterion should establish the presence or absence of technical links between the objects of the agreement. Number 6. It is argued that in order to provide better guarantees and ensure the rights of the private partner in the relationship with the Russian public authorities, the law on public-private partnership should envisage the possibility to conclude a single agreement for the public partner when public-private partnership projects are implemented by several legal entities. Number 7, it is argued that to minimize the risks that the initiator of the project might incur when participating in the private initiative, the law on public-private partnership should provide for the compensation to be paid by the winner of the tender to its initiator if the latter is a different entity. The amount of the payment should depend on the independent evaluation. Number 8. It is found that the law on public-private partnership includes provisions which constitute a significant derogation from the principle of fair risk and liability distribution between the parties, and put a private partner at a substantial disadvantage. First of all, we have criticized the provision that in case of early termination of public-private partnership agreement through judicial procedures due to a substantial breach of the agreement by the private partner, the ownership of the assets is automatically transferred to the public partner. As a result, the financing institution has no right to retain the pledged property. This provision puts the financial institution and the private partner at a substantial disadvantage. Therefore, it is suggested to clarify this provision of the law. Secondly, it is suggested to provide for the payment of compensation to the private partner and/or the financial organization in case of the termination of the agreement following the substantial breach of the terms of the agreement. Thirdly, it is argued that the law on public-private partnership unduly restricts the amount of compensation to be paid to the private partner if the termination was not due to the fault of the private partner. Diminishing of the amount of compensation, not only by the amount of losses incurred by the public partner, but also by the amount of losses incurred by third parties, unduly decreases the amount of payable by the public partner. Therefore, it is proposed to amend the law in this area as well. Moreover, the thesis contains proposals aimed at improving civil legislation on public-private partnership. Thank you. Thank you. Are there any questions? There are no questions to the candidate. We have not received any external reviews. Now, let's proceed with our agenda, and then now the board members will be reading out their report on the thesis. Okay, let's follow the order that is listed in the relevant order. The floor is given to the first board member.
So I have submitted my report on the thesis. The topic is Public-Private Partnership Agreement, Civil Law Aspects. In my report, I state that the topic is relevant. It's relevant because it is necessary to further theoretize the legal aspects which facilitate the development of legislation of public-private partnership. This is especially relevant in that way that despite we do have some scholarly works in this area, this institution of public-private partnership, to be more precise, the Russian modification of the private-public partnership institution, has not been thoroughly studied by our legal scholars. It still remains little studied. I'm not talking about foreign legislations. There they have been able to dig up deeper than our national scholars. So these dissertation really stirs interest, and it's really relevant. Now let me focus on the advantages of the dissertation. First off, I'm really in favor of one of the conclusions that the candidate has made. This conclusion is that PPP agreements are not mixed agreements. They are independent agreements which have their own object. This is the first research findings submitted for peer review. I suppose this is a very weighty conclusion. There are other advantages that the study has, and those I'm in favor of. Given an overall characteristic of this study, I would say that the candidate was able to achieve all the goals and tasks that she set. She has managed to produce a logical and a well-substantiated study. She has logical and well-argued recommendations and conclusions. Materials contained in this study are indicative of the personal contribution of the candidate when producing the conclusions of her study. She approached the study creatively, so I don't have any critical remarks concerning, borings of somebody else's ideas. Well, now I would like to point out some disputable issues. I have two of them in my report. First off, analyzing the legal regime of intellectual property rights, which are not protected by PPP law. So the PPP law does not contain the regime of exclusive rights, because the ownership right of the property may be taken by either private or public partner. This is something unclear. How do intellectual property results and property in general, what do they have in common here? Because here we focus on the law of things and a different domain of law. In this statement, I suppose you have a bit overdone on this conclusion. This is not the right place for the PPP law. When we deal with intellectual property, we deal with the Civil Code, Section 4. This is my first remark, and I would like to listen to your comment on that. The second critical remark that I have again has something to do with what the candidate offers. It's given on page 150 and in item 3, submitted for peer review. This is about introducing a statement about minor reconstruction and definition of this term. PPP law is not something that has to include this concept of minor reconstruction. Whether we deal with the concept of reconstruction or minor reconstruction, then we don't deal with the PPP law here. Here we deal with the Urban Development Code. So this is a domain where lawmakers can play with this terminology. Public-private partnership legislation is an absolutely different domain. These are minor inaccuracies. On the whole, the dissertation is written at a high level. So the dissertation is a qualification paper, and it's relevant to the development of entrepreneurship law. The thesis by Natalia Diatlova complies with the major requirements set forth in the relevant order. Order number 6821/1. Natalia Diatlova can be awarded the academic degree of the candidate of science in law. The specialization is 120003. Thank you for your attention. Thank you very much for the report. Now the floor is given to Aleksandrovna. Professor Aleksandrovna, you're welcome with your report. Good afternoon, colleagues, ladies and gentlemen. I won't be able, unfortunately, to be original because I have the same opinion about the relevance of this dissertation. I find it relevant for the same reasons as Professor Petrov announced. When I was reading the dissertation, I was expected to see certain challenges that the candidate could have faced. It has to be admitted that the candidate is a true expert, and she is really fully aware of all the details of this the study and of this phenomenon. So the relevance of the study lies in the legal evaluation of the PPP phenomenon. Well, there are certain contradictions that we find in the study. On the one hand, she is talking about the civil nature of such agreements, and the contradiction is as follows. Public-private partnership, according to the candidate, is analyzed both from the civil and public perspective of legislation. This contradiction is not the fault of the candidate. This is our national reality. She has been trying to be objective when analyzing and describing this phenomenon. However, the practical consequences of this phenomenon are really crucial. Such agreements are often contested, especially in those parts of these agreements which can be regarded both from the perspectives of civil and public law. These are the questions that the candidate focuses on in depth in her dissertation. Another issue is what is to become of that part of the PPP agreement that wasn't contested and that lies in the domain of public law. This is the key challenge of the study and of our reality. and I don't see any effective tools to solve this issue. Let me repeat myself. This is not the candidate's fault. This is the challenge she had to tackle. It is obvious that the candidate is an expert in this field, and I'm for conferring the degree. Thank you. Thank you for your report, Professor Skvortsov. The floor goes to Professor Yershova.
My report on the thesis is posted on the website, and I would like to confirm once more the relevance of the thesis. The topic is very interesting, and it's very topical as well. I would like to say that the aim of the thesis has been achieved, although I have said in my report about some inaccuracies in the aim, but it is not relevant. I also liked the structure of the thesis and the consistency of the thesis. I'm not going to speak about the structure of the thesis, since we have heard about it in the candidate's presentation. I would like to support some research findings about the independent character of the PPP agreement and the research finding about the possibility to conclude a single agreement for the private partner if there are several public legal entities involved, and the research finding about the non-exhaustive or exhaustive lists of the object of public-private partnership agreements. I'm not going to go into detail here, since we have heard about it in the presentation. I also like the suggestion about the minimizing the risks to the initiator of the tender if he doesn't win the tender. I would like to say that apart from the research findings submitted for peer evaluation, the thesis also has some other research findings which are quite interesting, and they could have been included into the list of research findings, since they are interesting from theoretical and practical point of views. For example, I think we should allow some public authorities to exercise the rights and obligations, and I support this research finding. I also like the idea about the possibility to conclude agreements between public, private and partners and subcontractors of agreements, and this idea is justified by the author. And the public service should also be regarded as a specific object of the agreement. There are some other statements and assumptions in the thesis which are interesting from the theoretical and practical point of view. I would also like to point out that although the thesis deals with business law, it is based on the classical legal doctrine. The author has studied the doctrine quite thoroughly, in my opinion, and therefore her thesis can be used for teaching as well. I liked the empirical aspect of the thesis. She made use of the administrative acts, of the court rulings, and of specific case studies and public-private partnership projects. This empirical aspect allows her to justify all her research findings. I also would like to point out her comparative method in the thesis. She takes into account the legislation of English and French law, and as my colleague has said, they have managed to dig up deeper in those countries. So the candidate for the degree was able to apply foreign legislation to the Russian reality. However, she took into account the fact that we cannot apply all the foreign experience and foreign legislation. Besides, her research findings can be used for further improvement of the Russian legislation, for teaching of civil law, business law and investment law. In the university where I teach, there is a textbook on investment law. When we are going to edit this textbook, we will definitely ask Natalia Diatlova to make her contribution to this textbook, if she chooses to agree, of course. However, there are some debatable issues in the thesis. I'm not going to read out in detail. So the civil and legal nature of the public-private partnership agreement has been discussed today. I do not quite agree with this characteristic of the PPP agreement. Moreover, the candidate for the degree states that public-private partnership agreements give rise to public legal relations inherent to PPP agreement due to the involvement of the public legal entity that concludes and implements PPP agreements with due consideration of the purpose of the public property. I think this conclusion about the civil and legal nature of the PPP agreement is in contradiction with some assumptions that we find in the thesis. In paragraph 3 of the first chapter, the candidate writes about the evolution of this phenomenon, and the candidate writes that public-private partnership should be determined with the use of the narrow approach. I would like to tell me what you mean by the narrow approach, since I don't always see the clear ideas about this in the thesis. On page 48 of the thesis, you write, and here I quote, "With the view of concluding and implementing PPP agreement, a special purpose vehicle is often created in the form of a Russian legal entity. Therefore, restricting the group of persons that can act in association with a private partner only to Russian legal persons does not generally prevent foreign legal persons from indirect participation in the implementation of PPP projects. This provision should have been directly stipulated by the law." End of quote. Here I would like to clarify what provision you want to include into the PPP law. And there is one critical remark about this structure of the thesis. The last chapter is not divided into paragraphs, and I think it should have been divided into paragraphs. Probably it's my subjective opinion. And I would like to say that the critical remarks are of debatable nature, and the thesis is done at a high value. It is an independent study which contains scientific novelty, and all the assumptions are justified. The major research findings are reflected in the publications And my conclusion is the thesis by Natalia Diatlova complies with the major requirements set forth in order number 6821/1 as of the 1st of September 2016. And Natalia Diatlova can be awarded the academic degree of the candidate of science and law. The specialization is 120033. Thank you. Thank you for your report on the thesis. The floor is given to Professor Martynenko. Dear members of the Dissertation Board, I would like to thank you for giving me this opportunity to participate in the defense. So I'm happy to be here and to participate in this defense procedure. Although the other members of the board have spoken about the relevance, I would like to point out one thing. The issues of public-private partnerships have been studied in various spheres of science, in economics and in law. As for the civil law and business law, we can say that there's a gap here in terms of public-private partnerships. So the objects, the subjects, the conclusion, the performance and the termination of PPP agreements have not been studied within the domain of civil law and business law. Therefore, the thesis fills in the gap here. Speaking about the justification of her research findings, I would like to say that the thesis is a single concept to the issue, namely to the issue of public-private partnership agreements, civil law aspects. For example, the author of the thesis is able to fill in the gaps in the area of public-private partnership agreements. She deals with such issues as PPP agreements and other issues. Her research findings are based on a thorough study of doctrines and legal documents. The author has conducted a comprehensive study of public-private agreements, and she makes her research in such areas as business law, civil law, and general law. The thesis also has an element of novelty. She has determined the subjects, the objects, the legal nature of PPP agreements. The theory of property is added by some important issues. For example, she speaks about the necessity to include into the PPP law a provision about minor reconstruction of the object of PPP agreements. There are some other research findings which I find relevant. For example, the research finding about a non-exhaustive list of objects. And here she speaks about two opportunities that are open here for the lawmakers. The thesis has a practical character, and there are several aspects to the practical character of the nature. We can improve legislation using the research findings. In my opinion, we can use the research findings for teaching and for writing textbooks. For example, in my university, there is a course devoted to public-private partnerships and legal regulation of the investment activities, which also partly deals with public-private partnerships. And of course, the thesis fills in the gaps in this area, and the research findings can be used for teaching these courses. So the overall assessment of the thesis is quite high. The topic and the content of the thesis are quite consistent. The research findings have been published in 4 papers. The candidate has participated in 9 conferences, and I like that the thesis is based on the empirical data. She has made use of 30 court rulings when preparing the thesis. And in my report, I have some references to specific pages in the thesis. However, I also have some critical remarks and some issues that should be debated or discussed further. For example, critical remark number 1. What is the originality of the assumption that the nature of PPP agreements is determined by civil law provisions? This is the research finding submitted for peer evaluation number 2. I believe that the law on public-private partnership number 224 has this idea. I believe that here the author should have given her own definition of public-private partnership. Probably she has this definition, and probably she will write about it in her further research. Speaking about the empirical data that is used in the thesis, I would like to say that Natalia Diatlova speaks about the amendment of the law on public-private partnership. However, I believe she should have specified these improvements. For example, I believe she should have provided some recommendations for drafting contracts or for making rules and regulations. It seems to me that the thesis could be used for practical recommendations in this area. We have already spoken about the fact that the thesis is based on the legislation of Russia, England and France. However, there are some other legislation, for example, the legislation of EAEU or CIS, and these countries have their own legislation which also deals with public-private partnership. I think Natalia Diatlova should make use of the legislation of these countries as well, because this legislation has some new assumptions and provisions. For example, this legislation defines the status of the consultant on public-private partnership projects. And also this legislation specifies environmental requirements and labor safety requirements. Probably the author will deal with this issue in her future research. I believe that the author has reached the aim of the thesis. The thesis describes the civil and legal nature of the public-private partnership. Therefore, the thesis by Natalia Diatlova complies with the major requirements. It is a graduate research work which reflects practical and theoretical assumptions and issues dealing with the public-private partnership and has made a contribution to this domain of law. Therefore, I believe that Natalia Diatlova can be awarded the academic degree of the Candidate of Science in Law. The specialization is 120033. And I would like to point out the main advantages of the thesis. She has identified the major aspects of the involvement of private and public partnerships of public and private partners. She has implemented a comprehensive approach to defining public-private partnership. She has spoken about the necessity to give either a non-exhaustive or exhaustive list of public-private partnership objects, and she has proposed two ideas here. I'm not going to go into detail here. Thank you for your attention. Thank you for your report on the thesis. And now I'm going to read out my own report on the thesis.
Отзывы были своевременно размещены на сайте университета, и у всех была возможность.
All the reports were posted on the university's website, so you could have analyzed them in some detail. Talking about Diatlova's research work, I would like to underscore its relevance. We are facing a complicated microeconomic environment, so attracting private business capital to implement different, especially infrastructure projects, is crucial to the economic development of our country, and these makes us conduct research in this area. The topic of the study and the study itself have scientific novelty. Recommendations, research findings, and conclusions are well substantiated. They're accurate. This is justified by a thorough analysis of relevant literature and analysis of evidence from legal practice. She has analyzed relevant legislation, laws and regulations. She has analyzed different viewpoints on this issue. The results are accurate due to the proper analysis that the candidate conducted. During her research, the candidate came to certain important conclusions. I think it's important to support the statement about enlarging the list of objects as part of PPP agreements. Another important statement is about a single agreement of public and private partners. There are some other statements that I'm in favor of. At the same time, some research findings submitted for peer review raise questions. I'd like to focus on research finding 2. Several board members stated that it needs review, it needs revision. So I'll skip that one. Much has been said about the second research finding. There are many other statements and conclusions that require comments on behalf of the candidate. My remark is about the technological link. So, as it says, it's recommended that the law on PPP should consolidate as a criterion to establishing presence or absence of technical links between the objects of the agreement, a comprehensive list of violations which restrict competition during the tender or provide their specifications in the subordinate legislation. I doubt that. Actually, antitrust law deals with other kinds of issues. And the list of the issues it deals with, the objects of the law, is a non-exhaustive list. So this requires a comment. It's found that Chapter 1, Article 13 of the law on PPP unduly restricts the amount of compensation to be paid to the private partner with respect to the profits from the investments made by the private partner on the borrowed capital, if the termination was not due to the fault of the private partner. Here, investment in macroeconomic risks, which usually referred to as entrepreneurial risks, they do not anyhow depend on the actions by public or private partners. Here, these risks have to be taken by the public partner. It's not clear why these risks have to be assumed by the public partner. Can you comment upon that? Overall, these two critical remarks that I have do not anyhow underestimate the overall value of the study conducted by Diatlova. It is a research of practical and theoretical value, so it's a complete independent study. The candidate was able to solve all the aims and goals she set in the conclusion, in the introduction. The thesis by Natalia Diatlova complies with the major requirements set forth in Order 6821/1 as of the 1st September 2016 on the procedure of granting academic degrees at St. Petersburg State University. Natalia Diatlova can be awarded the academic degree of the candidate of science in law. The specialization is 120003. Now, colleagues and attendees, we are through with one more item of the agenda, and the candidate has 15 minutes to comment upon questions of the board members. First off, I would like to thank the chair of the Dissertation Board, Professor Petrov, as well as members of the Dissertation Board, Professor Gordov, Professor Shova, Professor Martinenko, Professor Skvortsov, for their positive evaluation of my study. Let me now comment upon some debatable issues you pointed out. I have grouped some of the questions. The first question is about exclusive rights. So, unlike the law on concession, the PPP law does not anyhow the law on PPP does not establish any regime with respect to exclusive rights, while the law on concession agreements leaves the matter to the discretion of the parties to the PPP agreement. It seems that the law on PPP internationally leaves out the regime of exclusive rights, as upon termination of the PPP agreement, the property right to an object may either remain with the private partner or, in the cases prescribed by the law, be transferred to the public partner. Talking about minor reconstruction, some define minor reconstruction as regulated by the law on privatization. Therefore, I thought it was feasible to state it in my dissertation that PPP law can apply to any kind of reconstruction, including minor reconstruction. So the parties to the agreement have to choose that definition of reconstruction which is provided in the Urban Development Code of the Russian Federation. The legal definition given in the Urban Development Code is rather broad. It implies all possible activities and kind of works on capital construction objects. So, to avoid misunderstandings, PPP law has to include a provision that minor reconstruction is included into the concept of reconstruction of an object as viewed by the PPP law. Talking about the civil nature of the PPP law, the major challenge of the dissertation was about the legal status of PPP law. Hence the question of the members of the dissertation board. I concluded that PPP agreements are subject to civil law. However, we cannot fail to notice public law elements in these agreements because they contain public entities, a public subject, public financing goals that a public entity has. However, talking about public elements is only possible before the agreement on PPP is concluded. In the agreement itself and during its implementation, we have a complicated set of facts. So if the PPP agreement is concluded by a public order, it doesn't mean that it's a civil agreement, but rather a public agreement. Public conditions stop being public when the agreement is concluded, which is civil in its character. So it can be contested based on the civil regulation. Here we have Articles 2 and 24 of the Civil Code of the Russian Federation. It's obvious that the participation of public entities in the obligations do not make them civil. If we use an assumption that the public elements are used in these agreements to state that it's subject to public law, then we should recall the examples on the public procurement, for example, and others. Once the PPP agreement is concluded, public elements still remain, for example, in the area of monitoring and supervision. However, other elements are still subject to the civil law. An important conclusion is evidenced by a recent court ruling as of the 14th of September 2017. It's the Moscow Arbitration Court of Appeal. So in the concession agreement, they found the presence of civil elements, but not public elements. They stated this agreement, they defined this agreement to be civil. This will increase the number of similar cases. Talking about broad and narrow definition of PPP, let me explain. In a broad sense, we regard PPP as a special kind of cooperation of a public and a private partner. In its narrow sense, it's a contractual relationship which has its independent character. Russia
России, так как он наиболее близок к пандектной системе России.
Accepted the law on PPP. A broader approach to PPP in law might create confusion. Let me now focus on another question of Professor Schober. This is about the participation of foreign partners in PPP agreements. PPP agreements stipulate that foreign legal entities can participate in the implementation of PPP agreements as private partners through a specialized legal entity established in Russia. Concerning Professor Martinenko's question, let me state that I answered this question I have also already answered this question. I would like to specify though that I have submitted these findings for peer review because there is evidence proving that in Germany, France and Russia we have some legal scholars that state that such agreements are of public character. Court rulings and court practice in this respect is not consistent. As regards the question of the definition of PPP, let me say that the definition of PPP in its broad sense is a cooperation of public and private partners. It aims to enhance the quality of public administration and solving crucial social and public tasks. The current definition of PPP views that as a cooperation, as an agreement, or as a mutual activity. My conclusion is that PPP is a special kind of agreement of public and private partners that can be implemented through different contractual agreements. Narrow and broad definition is just casual. In a broad sense, it has some economic parameters that have to be taken into account. In its narrow sense, it's a special contractual relationship. Talking about PPP regulations in EU and CIS, I should say that I have analyzed this issue in my dissertation. Thus, I focused on the legislation of England and France. England was the first to introduce PPP projects. France is interested in this respect because of the continental law, which is somewhat similar to the Russian law, and their legislation in this area is really developed. In my further research, I will turn to PPP regulation in EU and the CIS countries as well. The next question is about the practical application of my research results. I can apply my research findings, and I'm actually already doing that in my everyday work. I'm head of PPP practice in Maxima Legal law firms. I was head lawyer in the project of constructed the Northwestern high-speed diameter. I'm a member of an expert council at the State Duma of the Russian Federation, and I'm developing amendments to relevant legislation, in particular when it comes to the concession law. Some of these amendments will be discussed in the State Duma shortly. The next question is about the criterion of the technical link or absence of technical link between the objects of the agreement. according to the antitrust law. Antitrust law focuses on what comprises antitrust behavior. However, the analysis has revealed that it's pretty difficult for courts to establish the presence or absence of these technical links. So in practice, what we have is just a list of objects that are subject to relevant legislation. So we should primarily avoid the narrow classification of objects. But what we would like to do is to introduce more property objects, but not to limit that. An exhaustive list of violations can limit antitrust actions, or we can develop a list of objects that technically cannot be united into one lot because of the lack of functional or technical link. Thus, we can enlarge the list of objects that can become objects of PPP agreements. The next question concerned compensations. When the agreement is terminated earlier, a compensation has to be paid. The amount of compensation paid by the public partner in case of early termination of the PPP agreement as a condition for transfer of the objects to public property is determined as the sum of expenses of the private partner reduced by the amount of the losses caused to the public partner and the third parties by such an early termination. In practice, this issue has to be disputed by the parties to the agreement, and this is something that has to be stipulated in the tender documentation. The sums paid to the public partner are often ridiculous, so the current regulation unjustly limits the amount of compensation, especially when it's done through no fault of his. Natalia, you can now take your seat. Thank you for your answers. Our next item on the agenda are the questions from the non-board members. Is there anyone willing to ask a question? Question concerning the dissertation. There are no questions from the audience, so now I would like Professor Vladimir Popandopoulos to take the floor with his report. Members of the dissertation board, we used to work together in the so-called old-style dissertation boards. Now you see when the academic supervisor takes the floor after the candidate, after the members of the dissertation board, and this explains everything. I'm really satisfied with the session. I do not see any difficulties or any problematic issues during this defense. I'd like to get a bit personal. What distinguishes the candidate is her independent approach to the study. I'm this kind of academic supervisor who does not impose his viewpoint on the postgraduate students. Sometimes we face certain contradictions because she has her own viewpoint and I do have my viewpoint, but well, she's an independent thinker and a creative researcher. her study is valid because it really has huge practical application. So in my report, I state that the candidate can be awarded the academic degree. Thank you, Professor Papandopoulou. According to our agenda, we have a discussion of the board members on the issue on conferring or not conferring the academic degree. Please switch off the broadcast, and I would like colleagues and attendees who are not board members to leave the room.
Продолжаем, да? Заседание продолжается.
Let's proceed with our agenda. Please switch on the broadcast and make sure that there are no technical issues, since this is a very important part of our defense procedure. So I put to the vote the issue on conferring the academic degree. Let me remind you that the decision of the Dissertation Board is positive, provided it has received 50% of the votes from no fewer than 3 members of the Dissertation Board. This is according to item 23 of the order on granting academic degrees at St. Petersburg State University. So, please, let's follow the list that we have on the order on setting up the Dissertation Board. Professor Gorodov, how do you vote? I vote for granting the academic degree. Professor Skvartsov, what's your opinion? I vote for. Professor Yershova, I vote for. Professor Martynenko, I believe Natalia Diatlova should be awarded the academic degree of the candidate of Science and Law. The specialization is 120033. As a member of the Dissertation Board, I also vote for granting the academic degree of the candidate of Science and Law. I'm sorry for this inaccuracy. Thank you for correcting me. So, dear colleagues and dear guests, I would like to say that out of 5 members of the board, 5 have voted for conferring the degree. So, this is a unanimous decision. The decision on granting the academic degree of the candidate of Science in Law. Specialization is civil law, commercial law, family law, international and private law. Now we give the floor to the candidate for the degree. Please be brief. I would like to give my thanks to Professor Papandopoulou, my research supervisor. I would like to thank him for his patience and for his support. I would like to thank the members of the Dissertation Board for their positive evaluation of my thesis. And I would like to thank my parents who are here, because they have also made their contribution to this defense. I'm very happy to be here. Thank you.
Уважаемые члены Диссовета, коллеги.
Dear members of the Dissertation Board, dear colleagues, so we are closing the session of the Dissertation Board. Please switch off the broadcast.